Officer Norris to Ms. Shelley Falk. Ms. Falk,
Yes, sir.
hey, how you doing? Can you do me a favor?
Doing well. What's up?
Can you give me a call at extension 22392?
22392. Got it.
All right, thank you.
Thanks.
All right, you ready to start? Good afternoon, everyone. Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good afternoon. All right, ladies and gentlemen, good afternoon. My name is Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have been recently arrested and charged with certain misdemeanor offenses. Soon after their arrest, Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and these cases have been bound over to the State Court of Fulton County. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we're able to address matters of bond, possible arraignment, and any possible plea offers if they have been made by the state at this juncture. I want to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. Defendants, you have certain constitutional rights, one being you have the right to have an attorney to represent you at this proceeding, which most of you do and know who they are by now. You also have the constitutional right to remain silent. Anything that you say about the facts, the circumstances, and the occurrences of your case can and will be held against you. The solicitors are here and they're listening, so please listen to your attorneys. All right, what do we have today, deputies?
Position 10.
Oh, I'm sorry. What's our reset date, please? For SAP?
November the 17th, Judge.
Okay. November 17th. Got it. All right. And I'm sorry, Deputy, tell me again.
Position 10.
Okay. This is case number 22 CR 007570F, Jasmine Troop, charged with 1 count of simple battery. The offense date is May 12, 2022. Pretrial.
Second arrest. Last was 2021, cruelty in the second battery. The cruelty was dismissed. The battery open in state court, 22 CR 007 412F.
All right. And would this be ASG Campbell?
Yes, Your Honor. Naomi Campbell on behalf of the state.
All right.
Good
Thank you.
afternoon. So the state's request for this particular matter is that Ms. Troop be given a $4,000 surety bond by this court. The state's also asking for a one-day anger management course, as well as no contact with the victim, Stephanie Harley. We're also asking that the court instruct Ms. Troop to stay away from the incident location, which is 3390 Fairburn Road, Southwest. Just briefly, Your Honor, the facts are that this defendant is alleged to have punched the victim, Stephanie Harley, in her face, causing swelling to her face as well as a laceration. The incident is alleged to have occurred on May the 12th of this year. So there was a warrant issued for her arrest and she was just picked up on it recently. And essentially the defendant was identified by the victim as the individual who punched her because the victim has known the defendant for 6 years. The reason why the state is requesting the $4,000 surety bond is because, as pretrial mentioned, this defendant does have an open court here in Fulton County State Court for the exact same charge with a different female victim. So that is concerning to the state. The state does believe that she poses a risk of reoffense as well as a danger to the victim in this case and other members of the community, considering the fact that within the past year, she's allegedly physically attacked 2 different other women within our community. So that is the state's request at this time.
All right. And on the PD side, who do we have?
Jay Kim, Your Honor.
All right, Ms. Kim.
Yes, Your Honor. Ms. Troop is 27 years old, Your Honor, and she was born and raised here in Georgia. She has 2 minor children as a single mom, 12 years old and 8 years old, and she does not get any child support as of now. And she's qualified for probably public defender's service, Your Honor. She works part-time at a warehouse to kind of prepare for events. And her education is, she was at high school 11th grade. Right now, she's taking classes at local library to get GED. Your Honor, my client denies the allegations, and actually she has videotapes and evidence to prove her innocence, and we believe she is innocent. So we would like to request for a signature on bond so she can go and take care of her 2 minor children who could not even go to school today, and they are with grandmother, and yet they really need their mom. Thank you, Your Honor.
All right. I'm going to order the $4,000 surety bond. I'm going to order no further contact with the victim, Stephanie Harley. I'm going to order that she stay away from 3390 Fairburn Road Southwest. I'm going to order no drugs, alcohol, or weapons while on bond. And there's nothing else that should be the order of the court. Anything else from council?
No, Your Honor, thank you.
All right.
Nothing further, Your Honor. Thank you.
I'm sorry, Judge, what was that bond?
$4,000 surety bond, the bond.
Thank you.
Uh-huh.
Position number 7 and 8. Ma'am.
All right, position 7 is Catherine, is it Stadig or Stadig? And I'm sorry for mispronouncing your last name. 22 CR 007561G. You're charged at 1 count of willful obstruction and a 2nd count of willful obstruction of a law enforcement officer, both with the offense date of November the 3rd, 2022. Pretrial.
We got 7 total. Last arrest was 2021, entering auto. Hit and run, simple battery. That was dismissed. Well, the simple battery and the hit and run was. 2020 probation out of Gwinnett. 2018 disorderly conduct, she pled NOLO. She had a case that was dismissed in 2018. Exploit, inflict pain on disabled or elderly person. I'm not sure what happened with that simple battery family violence charge. 2017 simple assault family violence dismissed. And DUI in 2000. That's it.
Okay. ASG Tortorello.
Yes, Your Honor. Good afternoon.
Good afternoon.
The state's recommending for the $4,500 surety bond to remain as set. No contact with the victim, Clifford Williams, who is on the Zoom. To stay away from the victim's residence at 1003. I believe it's Cimarron, CIM as in Mary, ARRON as in Nancy Parkway in Atlanta. To stay away from that address. 1-day anger management, ADET, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, just before I go over the facts of her battery case, I just want to point out to the court that there are prior difficulties between the victim and the defendant. She had a case up in Superior Court 22 SC 180567. Entering auto, criminal damage to property, simple battery. In this matter, Your Honor, the defendant attempted to run Mr. Williams over with a vehicle and she punched him in the nose. And this case was dismissed by the DA's office. There was also a civil suit, Williams versus Stadig. It's a for domestic violence. That was a 2021 CV 357704. I believe that was for a TPO. That Mr. Williams was seeking. This incident occurred on October 29th, 2022 at the incident location. This defendant poses a significant threat and danger to Mr. Williams. The victim, Clifford Williams, arrived to the Sandy Springs Police Department with his face and shirt covered in blood, according to officers. The officer observed Mr. Williams to have a laceration at the top of his head, bruising to his left orbital socket, and a scratch on his left cheek. Mr. Williams was visiting the defendant, and both parties got into a verbal altercation, which turned physical. When the defendant struck Mr. Williams from behind as he was attempting to leave the residence, and she struck him with an unidentified object, which caused Mr. Williams to have injuries to his head. This defendant was eventually arrested, and all these events occurred in Fulton County, Georgia. Your Honor, may I go to her subsequent case for the obstruction?
The same victim.
It's just the obstruction charge. She was arrested for the warrant for this case.
Okay, because on that case, let me call that one 22 CR 007563G. Catherine Stadig, you have 1 count of battery, and that offense date was 10/29/22. The 2 obstructions I have November the 3rd, 2022. Is that not correct?
That's correct, Your Honor.
Go ahead.
Yes, Your Honor. So in this case, the Sandy Springs Police Department responded to the incident location, that 1003 address in Atlanta. Officer Blank and Officer Burnside of the Sandy Springs Police Department met with the defendant at the front door and attempted to place her under arrest on an astounding warrant for the battery incident. The defendant resisted arrest by not following commands to walk to the patrol vehicle. The defendant continued struggling with the officers, tripped over her long dress, and then the officer fell to the ground with her. The defendant was arrested, and all these events occurred in Fulton County, Georgia. For this case, Your Honor, we're asking for $1,000 surety bond for each obstruction charge, which would be a total of a $2,000 surety. The conditions is no drugs or alcohol, no weapons, and no new violations of Georgia law. To add, Your Honor, we do have a different, we have that she has 16 cycles in her criminal history. She has a 2019.
In 16 or 60?
16, Your Honor, sorry. She has a 2019 simple battery conviction out of DeKalb County State Court. She was arrested on March 18, 2022 for criminal damage to property by the Atlanta Police Department. I'm not sure if that case is still open. A 2021 obstruction and criminal trespass arrest out of Atlanta. She has a 2021 FDA out of Fulton County and a 2020 FDA out of DeKalb. So for that reason, Your Honor, for the battery case, the case that was the CR number that was read on record, I apologize. For that battery, we're asking for the $4,500 surety, and for the obstruction case, we're asking for a $2,000 surety. Nothing further.
Which would be 1,000 on each. Okay.
Yes, Your Honor.
Okay. All right. PD Kim.
Yes, Your Honor. Ms. Stedick she has been here in Georgia for 42 years, all her life. And she has strong ties to the community. She has a job. She was working as a broker / data entry. She has a 3 bachelor's degree in college from Virginia, economics, finance, and fine arts. My client is actually denying the allegation. She was not the first aggressor, and indeed she was defending herself, and she would like to request for no further violent contact, so that way she can have a continuous contact with Mr. Williams, as long as it is not violent. And I guess Mr. Williams is here on the Zoom hearing, and he would like to request the court for certain conditions. We do request for a signature on bond, but considering the histories that has been addressed by state, we would like to request for a maximum $1,000 surety bond for all those charges, total of $3,000. Thank you, Your Honor.
And Your Honor, just to perfect the record, the incident location is actually the defendant's address. So we won't be asking for a stay away for that address, just that she have no contact with the victim.
Okay. And
Judge, I
then,
got a question.
Your Honor, I believe that I just kind of want to know about the 16 cycles, because it's so different from like 7 cycles. Because yesterday there was another incident that my client had only 4 charges of previous histories, but the state had like 20 some, a whole lot more than what it was. So I would like to know how she got 16 cycles.
Tartarella, our pretrial.
Because I only have 8, so I don't know how they got 16. That's why I don't know.
Your Honor, Clifford Williams.
Hold on a second, please, Mr. Williams.
Okay, sorry, ma'am.
I'm sorry, Mr. Williams. Your Honor, if I could have my supervisor double check for me, Deputy Falk, just to assure that I'm looking at the correct GCIC.
I will go and check that right now.
Thank you. While we're checking that, I will hear from the victim in this case, but not regarding criminal history. But Mr. Williams, can you turn your camera back on again, please?
My mic and my camera.
Both?
Yes.
Yes, there you go. All right. Mr. Williams, do you wish to address the court today regarding this case?
I will. I spoke with the.
Hold on a second. Hold on a second. Need to swear you in. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, thank you. Put your hand down. And what were you going to say?
I spoke with the DA's office and the public defender's office. I had requested a signature bond in regards to the incident from last year. About 4 of those cycles are all that one incident. The civil case was a TPO hearing. The March charge was a re-indictment of the initial incident charge. The facts were
Don't want you to tell
basically,
me the facts.
yeah, okay. Well, it was,
I only want to know about these 2
Right.
cases that are before me today, and those dates being October the 29th and November the 3rd.
okay, October the 29th.
And I don't want you to
It-
go over all the facts with me. The state has given me what we have, because this is not a trial. This is just a matter of determining bond and the likelihood of Mr. Digg to return to court. So I need to know, number one, are you in fear of Mr. Digg? Or Stadig, I don't know how to pronounce her last name.
It's state aid. No, I am not.
Okay, Stadig, okay. All right, and do you all reside together?
No, we do not.
And the address of the 1003 Cameron Parkway, that's your address?
Cimarron, and no, that is not my address.
Cimarron, that is Mr. Stadig's address.
Correct.
Okay. All
And
right.
I had requested that if she had some type of either anger management or treatment course, I have no problem with her having a signature bond. I'm not sure what happened on the 3rd, but as of the 29th, I certainly think she needs anger management. That's all I have on that.
Let me ask you this. So if you're not in fear of her being released, you all don't reside together. With the previous history and what has happened now, you still don't have any fears of any additional incidents? The
prior incident was blown out of proportion. It was ultimately a misunderstanding. The allegation that she attempted to run over me was not accurate. I don't believe it was even indicted in that. It was indicted as, or supposed to be indicted as, damage of over $500, which I believe is the class 2 of that charge, or the second one, or the second degree. It was just wrong. It was wrongfully indicted. It was wrong. It was incorrectly indicted to be the cause substantial bodily harm, which isn't what occurred. Was over $500 in damage from hitting my vehicle. And she had actually entered the auto to place value.
Hold on a second. Again, I really don't want to go into the facts. I know that are not before me.
There's
Also-
no, I do not. As long as she is getting some help and is barred from alcohol, I have no fear at all.
Okay, are you all still dating?
I've been sober for a number of years. I've been trying to help her do that, but romantically, no.
Okay,
Your Honor, may I ask a question of state's witness?
yes.
Mr. Williams, did you, on the day of the incident, did you go to the Sandy Springs Police Department?
Yes,
Why did you go there?
because without some type of consequence, I didn't see any type of behavior changing.
Were you bleeding?
Yes, it was severe. It was bad.
Okay. You stated to us that you had to get a TPO against her last year. Is that correct?
Correct.
And why was that?
Because as
Irrelevant,
the,
Your Honor, objection.
It's relevant, Your Honor, to the factors of the IOLA factors, Your Honor, for bond.
Briefly.
as her substance abuse problem increased, her behavior got more erratic, and that stopped it. It stopped her coming around and affecting my life at the time.
Nothing further, Your Honor, from the state.
Nothing further from defense.
And Your Honor, as far as the GCIC, there's a clear discrepancy between what the state has and what pretrial has. But that is the information we have for GCIC.
Was
Okay.
it the birthday was
Elliot,
March?
is there something?
Your Honor, I did just want to update. I received notification from our support staff that our GCIC was in fact, it appears incorrect, and we have corrected that.
Okay,
Okay,
Thank you, Deputy Falk.
so are we back to,
thank you.
but
Appreciate it.
pre-trial said 7 total?
Yes.
Okay. All right. All right, what I'm going to do is, on this first case, position 7, ending in 7516G, the 2 counts of willful obstruction, I'm going to grant a $2,000 signature bond through pretrial. That's $1,000 on each case. I'm going to order no further contact with the victim, Clifford Williams. I'm going to order the 1-day anger awareness course. And I'm going to order the ADET so that there will be an alcohol and drug evaluation done, and any recommendations for treatment will be followed by you, Mr. Digg, Stay Digg. So that's $2,000 signature bond through pretrial on the first case. On the second case, which is the case ending in 7563G, the 1 count of battery, I'm going to order a $4,500 signature bond through pretrial. With that 4,500 signature bond through pretrial, we already have the 1-day anger awareness and ADET on the other case. On both cases, I want to say no drugs, alcohol, or weapons while on bond, and that should be in the recommendations for both cases. Also, in both cases, no further contact rather with Mr. Williams, the victim, Clifford Williams. So Mr. Williams, she's not to have any more contact with you while she's on bond.
I understand, Your Honor.
Okay, I think we'll need that to make sure things are cooling down.
Your Honor, I just have one question, clarification about ADET. Is it going to be provided by pretrial services?
No, I think you said that she had income or was working, so she will have to pay for that herself.
Okay,
All right.
thank you.
All right, any other questions?
Yes, Judge, can you give me the breakdown again on the willful obstruction, this Melissa?
Okay, that's $2,000, $1,000 each case.
Position 6, no.
It's 22 CR 007568G, Darius Snow, charged at 1 count of willful obstruction, 2nd count of criminal trespass. The offense date is November the 3rd, 2022. What do you have pre-trial?
17 total. Last arrest was in September. 2 counts of shoplifting, 1 count trespass. He's on probation for that. It's 22 CR 006-616G. Also on probation for another shoplifting, 21 CR 002-590B. All right. He was arrested back in March. 3 counts of criminal damage to property, 2nd degree. 2021 FTA for shoplifting. November 2021 trespass, shoplifting, and obstruction. May 2021 shoplifting. 2020 driving without a valid license. 2020 failure to appear, criminal trespass. 2020 forgery in the 4th. 2019 criminal damage to property, second degree, theft by taking. 2019 trespass, the 2019 simple battery conviction, the 2019 simple battery in a public transit vehicle or station. Forgery fourth degree conviction from, it's like 2019. The 2011 theft by taking that was dismissed, and the 2010 shoplifting.
All right. Ms. Campbell, ASG Campbell.
Yes, Your Honor. The state's request with regard to Mr. Snow is that Mr. Snow receive a $1,000 signature bond on the obstruction, as well as a $1,000 signature bond on the criminal trespass, for a total of a $2,000 signature bond. The state is also requesting that the defendant be instructed to stay away from the incident location, which is 339 Old Wheat Street Northeast. Your Honor is familiar with his criminal history based on the information that pretrial just shared with the court. I would simply add that the reason why the state is essentially asking for a signature bond in this matter is because the defendant was on a vacant property as a part of a larger homeless encampment, and the police instructed the people on the lot to leave. This particular defendant, when he was asked to leave, he did not leave, and he got into it with the police officer. He didn't physically attack the police officer, but essentially he was aggressive towards the police officer, and the police officer had to draw his taser. So the state is fine with the signature bond in this matter.
All right.
Your Honor, we have no objection. I just want to clarify that it is a signature bond through jail.
Yes.
Thank you.
All right, so we will. That's right, and no victims. We just got to stay away from that incident location. Is that correct?
Yes, Your Honor.
Yes, yes, Your Honor.
All right, I will go ahead and order a $2,000 signature bond through the jail. I will order to stay away from 339 Old Wheat Street Northeast. And that's 1,000 on each charge. I will order no drugs, alcohol, or weapons unless prescribed drugs. And that should be the ruling of the court. Anything else, counsel?
Nothing further, Your Honor.
No, Your Honor.
All right. All right, that will conclude this case.
Position 2, Brown.
Hold on, move.
Huh?
Position number?
2. This is 22 CR 007556E, Dion Brown, charged with 1 count of battery family violence. The offense date is November the 3rd, 2022, pretrial.
6 total. 2016 out of Virginia, failure to appear. That was June 2016. May 2016, he had a DWI first offense. 2013 disorderly conduct conviction. 2013 October, it was also assault with that felony. That was non-pros. And a 2010 petty larceny. That was dismissed. 2017 out of North Carolina, felony larceny, fleeing and arrest. That was dismissed. And this is first Georgia arrest.
Okay. All right, ASG LS Duncan.
Good afternoon, Your Honor. This incident took place yesterday at 2460 Peachtree Road, apartment 403. The victim in this case is Kevin Fountain, both common spelling. In this incident, officers responded to a dispute call at that location. When they made it to that location, they encountered the victim in this case, Mr. Fountain, who indicated to officers that the defendant in this case who is his live-in boyfriend, had struck him multiple times with a Swiffer stick. Officers indicated that they noted visible injuries, including raised lumps on the victim's head, lower left arm, and that the victim in this case did have a busted lip. Upon arriving on the scene, the defendant was no longer at the scene. However, there was a second 911 call made by property management and others when they saw the defendant returning to the property later that day. And at that time, officers were able to make contact with the defendant in this case, and they were able to speak to him. And at that time, he did admit to getting into an altercation with the victim in this case, Mr. Fountain. And at that time, the defendant was taken into custody. Your Honor, in this case, the state has some concerns about the risk of reoffense, given this defendant's criminal history and given the information provided to us by the victim in this case. We were able to make contact. He did state to us that this is not the first time that something like this has happened in their short relationship of about 5 months. He stated that he's had to call the police about 5 or 6 times. We also have some concerns about intimidation of this particular witness and the safety of this particular witness. However, because they do live in the same household, and we have concerns about the cycle of violence in this case, given that when he spoke to our victim advocate, he was unsure of how he felt about proceeding, and he cited being in love with the defendant as the cause for that. He did state at the time when talking to our victim advocate that he no longer wanted contact. He would not want the defendant to come back. He believes that the defendant should get a one-time escort to get the belongings. However, he no longer wanted the defendant to return to that address. We also have some concerns about the flight risk in this case, Your Honor, given that recent FTA on the history. We do believe that the victim is on the call, if Your Honor would like to sound for him when appropriate. And I'm sorry, my apologies. Our recommendation in this case is a $5,000 surety, given that we believe there is a severe risk of intimidation of this victim. And we're also concerned about the safety of this particular victim, given what we've learned from our contact with the victim today and the facts as alleged. We'd ask for no further contact and stay away from the incident location that's on record. 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law.
All right, Mr. Is it Kevin Fountain?
Yes, can I speak?
Raise your right hand first for me. I want to swear you
Right
in.
here you go.
All right, do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, put your hand down, and what would you like to tell me about this incident?
Okay. In every relationship, little things might happen. Like, I'm the only person he has here. I moved him here. He has nowhere else to go. So I'm asking you on my recliners, could you please just help us out? Because this will never happen again. Everything has happened. Everything that has happened shouldn't have it. It don't matter. Like Atlanta 911 is like they're lying. If I just want to throw away the charges.
Well, at this point, we can't do that because the police were called and we do have a report. We've gone past probably.
But let me tell you what they did, Your Honor.
Hold on. And the case has been accused. Okay. So we're going to have to let the legal process carry itself out at this point. Are you in? Let me ask you a few questions. Are you in fear of Mr. Brown?
No. Shut up.
Okay. And so if Mr. Brown were released, you don't believe there'd be any more incidents?
I don't think it would be no more incidents at all.
And Your Honor, if I may I ask a few questions of the victim in this case?
Objection. Yes, Duncan.
Objection. The questions go towards the Ayala factors present in the case in response to defense's objection.
Right, go ahead.
Mr. Fountain, isn't it true that you've spoken with the defendant in this case since he's been incarcerated on these charges?
That's my husband. That's my fiance. Why wouldn't I?
So are you saying right now that you have spoken to the defendant since he's been incarcerated on these charges?
I have. That's my fiance.
Okay, are you aware that the charges, that the calls from the jail in these cases are recorded?
So you asking me a question that you already know
Yeah.
and understand.
Okay, answer her questions, please. Just not with all
Yes.
the extra. Just
So
answer the questions for now. You are under oath, and just answer with not a lot of extra, please. Go ahead.
So you are aware that jail calls in these cases are recorded, correct?
Yes, ma'am.
Isn't it true that the defendant asked you on a phone call from the jail to drop these charges?
Objection, Your Honor.
It's relevant to intimidation of the witness, Your Honor, and I'll a factor for bond in this case.
Go ahead and proceed.
Isn't it true that on one of these calls, the defendant asked you to drop these charges?
Yes.
Isn't it true that you stated to the defendant that you would drop the charges if he promised to change his behavior?
Yes.
Your Honor, clearly as indicated by the victim's responses to these questions, our concern for intimidation of the witness is present, given that the defendant is contacting this victim from jail and intimidating him in terms of asking him to drop the charges and using their relationship as a counterpoint for that. As Your Honor is well aware of the cycles of violence, we do believe that given the facts and circumstances present with those recorded jail calls, that $5,000 surety is more than reasonable. Nothing further from the state.
All right, Ms. Gann.
Thank you, Your Honor. Mr. Dion Brown is 30 years old. He states that he has been in the Atlanta, Georgia area for about 8 months. He does have family here, including Mr. Fountain, who is on the Zoom call. He also has cousins and a sister. He completed high school. He states that he has an associate's degree in software security. He is currently employed at Crossmark Sales Company. He states that he just found that job. He has been in that position for about 1.5 months. Therefore, he is still on probation and he's very concerned about losing his job. In addition, Your Honor, he states that he helps Mr. Fountain with his businesses. He states that they both sell clothing and that Mr. Fountain is a chef and he often functions as his sous chef. Mr. Brown strongly denies the allegation, Your Honor. He states that he in fact was injured. He has scratches on his neck and hands. He states that he was attacked initially and that he was merely defending himself, which he is certainly allowed to do under the law. And Your Honor, I will just remind the court that this is a bond hearing. This is not a trial. This is not a trial. It's certainly not based upon whether or not my client is guilty or innocent. And certainly, Your Honor, I had the occasion to speak to Mr. Fountain. He informed me the exact same thing that he informed this court, that he's not afraid of Mr. Afraid of Mr. Brown regarding my client's history. Clearly, he has no convictions of violence. We heard about an assault many years ago that was no cross. We heard about a DUI, that's a driving offense. We heard about a fleeing, attempting to elude. His last FTA that I heard about was in 2016. That's about 6 years ago, Your Honor. He is recommended for a signature bond. Again, he wants contact with Mr. Brown. Again, they work together. So I'm asking this court for a signature bond on Mr. Brown's behalf. I would ask that Your Honor not put in place any no contact and stay away provisions. And if Your Honor determines that that is appropriate, then I would ask for a one-time law enforcement escort for Mr. Brown to retrieve his belongings. And lastly, Your Honor, given that my client has not been convicted, we do not believe that the state has put forth any sufficient facts or argument to support its basis that my client will reoffend. Thank you, Your Honor.
And Your Honor, if I may, this victim, Mr. Fountain, gave the exact opposite recitation to our victim advocate this morning, where he stated he did not want contact. He did not want the defendant to come back around, and that this violence is a continual in nature in their relationship. So we believe in the best interest of the victim in this case, and for his safety, we're going to ask that the court grant our recommendation. Nothing further from the state.
And Your Honor, I do apologize for interrupting. I would just say that that goes to the credibility of the state's witness, and my client enjoys the presumption of innocence. Thank you, Your Honor.
And as your honor is aware of the cycles of violence, nothing further from the state.
Thank you. All right, I am concerned regarding some of the evidence that I've heard. I don't know that there has been, I don't believe there's been enough cooling off period just from yesterday. And so and I've also heard that the defendant does have somewhere else he can go stay. But I am concerned that the parties need a cooling off period and need to be separated. I'm going to order a $5,000 surety bond. I'm going to order that the defendant stay away from 2460 Pine Tree Road, number 403. Stay away from that location. I will order the one-time law enforcement escort for him to get his belongings, to stay away while on bond. I'm going to order at this time no further contact with the victim, Kevin Fountain, for the safety of the victim. I'm going to order no drugs, alcohol, or weapons while on bond. I think that's all I will order at this time, council. I'm not going to order the one-day anger awareness course yet. Let that play out as the case progresses. Anything else, council, that I need to take up?
Nothing further from the state.
Nothing further from the defense. Thank you, Your Honor.
Thank you. All right, thank you. Thank you, Mr. Fountain. Good luck to you.
Position 3, Clark.
I had asked the courtroom that I speak with Mr. Clark before his case is called, as I have had some issues contacting his a potential co-signer for his bond.
Okay.
I just want to make the court aware that this is a co-defendant case with position 9.
No, go sit at the phone.
Position 9, bond it out.
Position 9, bond it out.
Okay, so can Mr. Clark talk to his attorney first?
Yes, I have him sitting at the phone. You can talk. And I'll do Kim's cases.
You can show me how to.
No, just.
Go to the phone.
All right, which case do we have next?
Quindarius Weaver, position 12.
Okay. This is 22 CR 007559A, Quindarius Weaver, the charge of 1 count of driving, hit and run, duty of a driver to stop at or return to the scene of an accident. The offense date is May the 7th, 2022. Pretrial.
His 9th arrest. Last arrest was last year in November for hindering person from making emergency call. 2014 forgery in the 4th degree. 2014 probation, theft by deception. It was not prosecuted. 2014 FTA, not prosecuted. 2013 hindering person from making emergency calls, simple battery. Cruelty in the 3rd and criminal trespass. It was 2 counts of simple battery. All those charges were dismissed. 2013 another probation. He was convicted for 6 counts of theft by deception out of Gwinnett County, 2013. And he had a 2012 CWAC that was dismissed. This was an SOB jail recommendation. FYI.
Thank you. All right, ASG Campbell.
Yes, Your Honor. The state's recommendation for this particular matter is that this defendant be given a $3,500 surety bond on the sole count of failure to stop at the scene of an accident, hit and run. And the state would also be requesting that this defendant be instructed to not drive while he's on bond. Something that I would like to add to pretrial's recitation of the defendant's criminal history is that he also has a very lengthy driving history, to include a 2022 failure to maintain insurance, for which he took a NOLO plea. He also has a 2021 failure to obey the traffic signals, a 2021 speeding. He has a 2018 speeding, a 2015 driving while his license was withdrawn, for which he also received a NOLO. In traffic court, he has a total of 2 FTAs, and those both resulted in FTA suspensions of his driver's license. And he also has a 2011 failure to obey signs or traffic control device. In addition to the criminal history that pretrial noted, I also like to note that he has an FTA in state court as well. So the state has a total of 3 FTAs, as well as numerous driving infractions. And at issue in this particular matter is the fact that back in May of this year, this defendant allegedly struck another motorist from the rear while on the interstate on 285 North. And allegedly this defendant was the driver and he had a passenger in the car. According to the passenger in the vehicle, when the defendant realized that he struck another motorist from the rear, he called his mother to come pick him up from the scene of the accident, essentially to evade taking responsibility for this accident. His mother did pick him up from the scene of the accident. So by the time that the police arrived, the defendant was not on scene, and the motorist had to tell the police that he was struck from the rear and that the person who struck him from the rear left the scene. The passenger in the vehicle was able to identify this defendant, Quandarius Weaver, as the person who was driving the vehicle. So the state does have serious concerns about his risk of reoffending, not just with his criminal history, but more specifically with his driving history being as lengthy as it is. He doesn't really seem to have a regard for other motorists on the roadways. And it seems like he continues to do things that put other motorists at risk and put himself as risk as well while he's behind the wheel of a car. So the state would be asking for that $3,500 surety bond and that he be instructed not to drive while he's on bond for those reasons.
All right, thank you. Ms. Kim?
Yes, Your Honor. Oh, give me one moment. I'm not sure why it's so echoing, but anyway, Mr. Weaver is 29 years old, Your Honor. He has a strong ties to the community. He's from Georgia. He was born here in Georgia. He has a 1-year-old, 8 years old he has to take care of as a single father. And he has a full custody, of course. So he's working at warehouse, manufacturer place. I mean, very, very much. He has a forklift license, and also he's a certified nursing assistant. He graduated from high school. We would like to request for a signature on bond. And yet, if Your Honor is not inclined to give him a signature on bond for the traffic violation, we would like to request for maximum $1,000 good bond. Thank you.
All right. I'm going to, excuse me. I'm going to order a $3,000 surety bond. Excuse me. I'm going to order $3,000 surety bond. No drugs, alcohol, or weapons while on bond. Excuse me. I don't know if everyone heard me. A $3,000 surety bond. No drugs, alcohol, or weapons while on bond. And I guess that's all that I can order in that case. Anything else, counsel?
Nothing further, Your Honor.
No, Your Honor.
All right, thank you.
Position 11, Capers Weaver.
All right, this is 22 CR 007567F, Caprice Weaver. Charged with one count of certain acts on a bus, rail, or station that are prohibited. Second count, possession of marijuana less than an ounce. Excuse me, and a third count of criminal trespass, all with the offense date of November 3rd, 2022.
This is fifth
Redraw.
arrest.
What number? I'm sorry.
This is fifth. Last arrest was in August. Trespass, terrorist threats, obstruction. That was on Marta. 2021 disorderly conduct, obstruction. That was dismissed out of Doraville. 2019 FTA carrying concealed weapon. Reckless conduct. 1, 2, 3. 3 counts of reckless. 1 count carrying weapon without a valid license conviction. That's it.
All right, ASG Campbell.
Yes, Your Honor. The state's request of this court for this particular matter is that the defendant be given a $1,000 surety bond on the criminal trespass, a $500 surety bond on the acts prohibited on a train or MARTA rail, and a $500 surety bond on the possession of marijuana count. And the state is also requesting that this court instruct the defendant to stay away from all MARTA stations and buses, any type of public transportation while he's on bond. And the reason for this request of the court is because, as pretrial mentioned, this defendant does currently have an open case from an incident date of August the 15th of 2022, so about 3 to 4 months ago. Where essentially he got very similar charges: criminal trespass, terroristic threats, and obstruction. And MARTA police made that arrest as well. The state was unable to get additional information as to the current status of that case or even what court it's pending before, but it is an arrest on his GCIC, and the arrest was made by MARTA police. So the state does believe that he poses a risk of reoffending, considering the fact that he has these 2 very similar occurrences within a very short time period. And in this particular instance, he was observed possessing a blunt with suspected marijuana while he was inside the MARTA station. He had also been previously banned from MARTA. So while he was using this blunt and possessing this blunt, he was not supposed to be in the train station to begin with, because MARTA police banned him from the MARTA station back in August of this year. So that is the reason why the state is requesting a $2,000 total surety bond for these occurrences.
Your Honor, Caprice Weaver is 23 years old, Your Honor, and he has a child who's only 16 months that he has to take care of. So he's been working as a cook, and he's afraid that he may have lost his job by now. He graduated from high school, and right now he is going to be residentially challenged, after this incarceration. He does not have means to pay for the bond at this point, Your Honor, and also stay away from the MARTA and all public transportation for the public, the indigent citizens, is too harsh, because he has to go to work. It's not like he can walk to the work or take a bike, other than like having no public transportation is just unreasonable, Your Honor. I think he should be respect and comply MARTA suspension, and yet other than that, I think he should be allowed to use MARTA or other public transportation. He can be actually limited to have stay away from that one incident location, that station only. However, other places he should be able to use it. And we would like to request for a signature on bond because $2,000, even that is no bond for him, Your Honor. So we strongly request for a signature on bond. Thank you.
I believe you're on mute, Your Honor.
I'm sorry, I was coughing. I'm going to order a $2,000 surety bond. I'm going to order the breakdown for that surety bond would be 500 for the certain acts, 500 on the possession of marijuana, and 1,000 on the criminal trespass, for a total of a $2,000 surety bond. I'm going to order, again, a stay away from all MARTA and public transportation. There's ways to get around. Other people do it through Uber and share rides and things of that nature. And even since there was a prior ban, I'm just going to continue with the ban from all public transportation. And so remember, Mr. Weaver, if you go back to get on MARTA or bus, there's cameras that will recognize you and you just end up being arrested again. So please stay away from all buses and trains from MARTA. I'm going to order no drugs, alcohol, or weapons while on bond. That should conclude the ruling.
Position 1, Bland.
All right, this is case number 22 CR 007562G. Roland Bland, you're charged with 1 count of theft of services with the offense date of June 22nd, 2022. Pre-trial. Pre-trial. State, do you have the criminal history?
I do. I believe there's one out of Virginia that was a 2017 conviction for grand larceny of stealing property, not from a person. And then there was 2 out of Georgia. This defendant does have an open felony theft by shoplifting case. It's 22 CP 213670. And that incident was from June of 2020. As it relates to this incident, it is from June of 2022. It occurred at the Bar Taco restaurant located at 3802 Wasboro Road, Northeast in Atlanta. In this incident, the defendant is accused of running up a bill of about $482.57 and attempting to swipe several credit cards with his name on it, with the manager who was also serving the table, Ming Bice. And all of those cards declined. And when those cards declined and the payment was not able to be processed, the defendant got up and left the restaurant. However, his tag was captured and police were able to run down that tag as being a car belonging to the victim or his family. They spoke to the defendant's father, who further identified the defendant in this case. As I said before, Ming Bice is the manager. So we do have some concern in this case about the risk of reoffense. Just 2 years ago, this defendant had a theft by shoplifting case that is still open. Therefore, the state is going to be requesting, given that risk of reoffense that's present in this case, a $4,000 signature bond through pretrial services, a stay away from that Bar Taco restaurant and at the incident location stated on record, no alcohol, drugs, and weapons, and no further violations of Georgia law, as well as a theft class. Nothing further from the state.
Judge, I had to go get the history. He went to felony earlier. Can you send that through to jail? He's a resident of Maryland.
Oh, sure.
He's a student at Morehouse. We prefer that he be monitored since this is his second offense. So he will be in now. I have an open theft by shoplifting for felony, so the state would request that he be monitored. It was
Oh, well,
indicated.
let me get a Virginia history then.
Okay.
Hold on. Yeah. 2016 identity theft. 2 counts. That was dismissed. 2017 petty larceny conviction. That's it.
Okay,
So yeah, he has a total of 1, 2, 3. It's like his 4th arrest.
okay. All right. Go ahead, Ms. Gant.
Thank you, Your Honor. Mr. Roland Bland is 25 years old. He has been in the Atlanta, Georgia area for 5 years. He is, in fact, a student at Morehouse. He is a senior. He has a dual major. He's majoring in physics and psychology. He states that his GPA is 3.4, and when he graduates, he plans to further his efforts to be an entrepreneur. He states that he is in business part-time, self-employed for a clothing design company. He does not have any resources to bond out of jail, Your Honor. We are unopposed to the state's recommendation for the $4,000 signature bond, if I heard correctly. We are unopposed to any stay away conditions, and we are opposed to the theft class, Your Honor. He enjoys the presumption of innocence, Your Honor. And I do not believe that he will be able to afford that class. Thank you, Your Honor.
Okay, I'm going to order her judge the $4,000 signature bond through pretrial. And that will be $4,000. I'm gonna order stay away from the Bar Taco, 3802 Roswell Road Northeast. I'm going to order no drugs, alcohol, or weapons while on bond. And pretrial, is there a theft class? Do y'all have that?
I'm not sure.
I'm sorry.
I don't know.
Okay. I'll order the theft class. I don't know if it'll be through pretrial or not. And I think that should be it, with no drugs, alcohol, or weapons while on bond.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Position 3, Clark.
This is 22 CR 007564E, Brandon Clark, charged with 1 count of marijuana, possession less than an ounce. 2nd count, possession and use of drug-related objects. 3rd count, possession of a pistol or revolver by a person under the 18 years of age, all with the offense date of November the 3rd, 2022. Pre-trial,
First arrest.
you said 5th?
First.
Oh, first. All right, go ahead, Ms. Duncan.
Your Honor, as I stated previously, this was a co-defendant case. However, his co-defendant, who was his father, has bonded out. This incident did occur yesterday in the area of Hank Aaron Drive in the Summerhill community. Officers were on patrol as a part of an Operation Fall Frontier. They noticed a vehicle committing several traffic violations, so they proceeded to conduct a traffic stop of that vehicle. That vehicle was being driven by the co-defendant in this case, and the defendant in this case was in the passenger seat of the vehicle. Upon officers making contact with the vehicle and the vehicle window being rolled down, officers did detect the odor of raw marijuana and observed the tray with marijuana residue on it on the floorboard under the driver's feet. The defendant, who is 17, was in the car with his father at that time, and once they were asked to get out of the car, The defendant in this case was allowed to retain use of his hands because according to officers, he was on a crutch, but he was asked to come to the back of the vehicle. And at that time, officers search incident 2 that they uncovered a packet of commercially packaged amount of marijuana, less than an ounce, in the hoodie of the defendant. They asked the defendant to release whatever he was holding on to in his right pocket. However, he did not at that time. Officers were previously told by the other party in this case that there were no firearms in the vehicle. However, when this defendant was asked to release his hands, he would not do so. Officers advised that they saw him holding on to something that carried a little bit of weight. They were eventually able to recover a loaded .40 caliber semi-automatic Glock pistol from the defendant in this case, Your Honor. And then the defendant also admitted to officers that the grinder that was in the car with marijuana did in fact belong to him. At that time, both parties were taken into custody. The state is aware of this defendant's limited criminal history. However, we have a huge concern that this defendant may be a danger to himself and others, given that there was a firearm and illegal drugs involved in this incident. As is stated for the record, this defendant apparently was on crutches. This situation could have gone much, much worse. Had he possibly tripped or fallen, he could have shot himself or anyone in the vicinity. Being a minor, that's even more dangerous, the fact that he was allowed to have such a weapon loaded in his possession under these circumstances. So given that, we think that a $4,000 surety is more than reasonable in this case. $500 for the possession of marijuana less than an ounce, $500 for the possession of drug-related objects, and $3,000 for the firearm under the age of 18. Your Honor, given these circumstances and the danger that a firearm itself presents under these circumstances in the hands of a minor, we believe it's more than reasonable. We're also going to ask for no alcohol, drugs, and weapons, no further violations of Georgia law, no contact with the co-defendant. We understand that that is his father, but we do have concerns about his contributing to the delinquency of this defendant. We also would ask that this defendant have a curfew from 9 p.m. to 6 a.m. Nothing further from the state.
Is this Ms. McLeod?
Your
No,
Honor,
Your Honor, it's Ms. Gams.
Oh, I'm sorry. Okay, Ms. Gant, sorry about that.
Thank you, Your Honor. Mr. Brandon Clark is 17 years old. He has been in the Atlanta, Georgia area his entire life. He does have his father here, the co-defendant, Mr. Robert Terry. He also has an aunt, Ms. Paris Terry. I have been in contact with her. She is willing to co-sign for Mr. Clark. I am not able to contact Mr. Clark's mother. And I have been unable to reach Mr. Clark's father, Mr. Robert Terry. He was just released, Your Honor. Mr. Clark is a high school student. He's in 12th grade. He is enrolled at the Perry Academy. He enjoys math and science. And of course, he is certainly considering attending college when he graduates. He is unemployed, Your Honor, but he does have some work history. He worked about 3 months ago at Chick-fil-A part-time while continuing in high school. He, of course, is presumed innocent. We are denying the allegations today. And regarding the state's arguments, Your Honor, this is not a reckless conduct case. Nothing happened. This is not a defects case, Your Honor. So we, again, my client, I have to remind the state that my client enjoys presumption of innocence. This is his first arrest. I am requesting a signature bond on Mr. Clark's behalf, given that he does not have the means to have anyone bond him out of jail. If Your Honor determines that he is ineligible, then I would ask for a split bond, and that would be a bond of no more than $1,000 for the possession of the pistol and to any amount that Your Honor deems appropriate in signature for the possession of marijuana and drug-related objects. We certainly are opposed to the no contact order with the co-defendant, which is the 17-year-old young man's father. Your Honor, again, this is not a defects case. And lastly, we are unopposed to the curfew. Thank you, Your Honor.
And if I may, Your Honor, as the court is aware that this is an open and pending case against this defendant and all co-defendants involved in the case, and the state reserves the right to add additional charges at that time. As stated before, we do have concerns about the father's contribution to this defendant's delinquency, given that he was allowed to possess a pistol or a firearm under the age of 18. And even if nothing happened as far as the discharge, we do have some concern about public safety and this defendant being a minor with possession of that type of weapon, which, as everyone knows, is extremely dangerous. So nothing further from the state.
And Your Honor, if I may, I neglected to ask that Attorney McLeod if she has some information regarding her client's wish, Mr. Terry, regarding contact with my client, Brandon Clark. I'm not sure if she has some information to provide to the court, Your Honor.
I do,
Yes,
Your
have
Honor.
spoken
I
to
was
his father.
representing Mr. Terry before he bonded out, and he expressed to me that he does want contact with his son. He has 5 children, and he's very, very involved with all 5 of them, he tells me. Even though they don't really live with him, he spends a lot of time with them. And he does want to have contact with his son, Your Honor.
Under these circumstances, the state would just object to that contact. Given these circumstances, we don't believe it's appropriate for the safety of this defendant at this time. Nothing further.
And we do have the co-signer.
Yes, Your Honor, Paris Terry, his aunt. And she informs me that she has a utility bill and ID, government issued ID.
And you're saying Paris, P-A-R-I-S?
Yes, Your Honor. Terry, common spelling, T-E-R-R-Y.
All right, I'm gonna order a signature bond through pretrial
This is per judge.
per judge. Yes, I want him to be monitored. And co-signer would be Miss Paris Terry. I want him to stay away from the Hank Aaron, Summer Hill area. And no further contact with the co-defendant, which is his father or stepfather.
His dad, Your Honor. That's his dad.
It's a tight one. I guess he's going to go and live back at home. Is that correct?
From what defense is stating, they don't live together, Your Honor.
They do not live together. Okay.
Right.
They do not live together, Your Honor, but he spends a lot of time with all of the children. This is
Oh,
what
he's
he
gonna have to right now not spend any time with his dad. You all have a case going. You're under bond conditions of no further contact with your dad, the co-defendant in this case, while you're on bond, and that's Mr. Robert Terry. So no contact with him. Please honor that, Mr. Clark. So you're not to talk with your dad right now, okay? No drugs, alcohol, or weapons while on bond. Not even to be around weapons at all, hopefully ever, but not while you're on bond, okay? That could violate your bond conditions and get you back in jail. Anything else, counsel?
What is the breakdown?
I'll do the breakdown and the curfew, 2 things. Let me do the curfew first. The curfew, Mr. Clark, you are to be in the house at by 9 p.m. and you can't go back out till 6 a.m. Where does he go to high school?
Perry Academy, Your Honor,
Where is that?
in Clayton County.
Okay. Well, but you should be able to be home by 9 p.m. or sooner. And then must stay in the house until 6 a.m. Time to go back to school. I want to put in there that you must go to school. Hopefully on track to graduate. And the breakdown, $500 on the marijuana, $500 on the possession of drug-related objects, $3,000 on the possession of the pistol for a total of $4,000 signature bond. All right, anything else, council?
Nothing further from the state.
Okay.
Nothing further from the defense, Your Honor, and I did place Ms. Terry's number in the chat to pretrial.
Okay, thank you.
You're welcome.
You call them when you get a chance.
Surely will. Thank you.
You're done. You can have a seat in the first row. Judge, I have a quick announcement for position 5. It's going to be waiver appearance. And position 9 bonded out. And position 1 add-on, he's in Cobb County.
Oh, he's not even there.
No, he's in Cobb County.
Okay. So
And
that-
Where's number 4?
Your Honor, I represent the
He is-
add-on and I haven't had a chance to speak with him yet.
Okay, well, I don't think you'll be able to do that today, Ms. McLeod.
Yes, Your Honor.
And position 4, I did submit a waiver for her appearance, and I am requesting a breakout, Your Honor.
Oh, go ahead, Ms. Duncan. I think you were about to say what I was about to ask.
And the state would object to that breakout room. What's the basis, Ms. Gant?
I have not stated the basis and you're objecting. However, I am objecting because I am requesting the breakout due to the nature of the charge. I do have serious concerns about my client's safety. This is public advertised on YouTube, and she's presumed innocent.
And we would object on that basis to the breakout room. The state does believe that all relevant parts of the case can be discussed without any danger being posed to the defendant in this case. For the record.
Judge, can we be excused? We're completed here in courtroom 2.
Yes.
Thank you.
Your Honor, may I be excused? My business is concluded for today.
Yes, we'll let you go as well.
Thank you.
All right.
Have a good weekend.
Let me hold on for 1 second before I give a ruling on whether we're going to go in a breakout with case number 4 and 5. Both have waived their appearance, and those are the 2 that we have left, correct?
Correct.
And I'm sorry, what's the basis for position 5 for going to a breakout?
No, we did not request a breakout for position 5. I waived his appearance.
Thank you.
All right. Hang on for 1 second. Let me recess for a second. All right, we're back on the record. Let's take position 5 and then we'll take 4 last. And I think we can do 4 on the record without sounding for certain matters and sensitive issues. And I'll make sure that both parties understand that. But we will stay on the record with case number 4. There's been a waiver, but we'll also make sure that we're very confidential and sensitive to any facts in that case, but I will sound for it and we'll stay on the record for that. Position 5, which is 22 CR 007566Y, State versus Michael Posey, charged with 1 count of criminal trespass. The offense date is November the 3rd, 2022. What do you have pretrial?
Well, this is his 100th arrest.
Oh my goodness. Okay. 100th arrest. Okay.
Talk about a milestone.
Yeah.
Last arrest was in March. Disorderly conduct, simple battery, criminal trespass, damage to property, terroristic threats, trespass, simple battery, and robbery by force. Before that was January, simple battery, family violence. 2021, simple assault, disorderly conduct, conviction. 2020, got armed robbery, ag assault, possession of a knife or a firearm during a commission. The armed robbery and possession was dismissed. He did get 2 simple battery convictions. One of them was family violence. 2019 probation for shoplifting. That's 2 counts of probation. 2019 FTA for terroristic threats. 2019 shoplifting. 2019 FTA shoplifting. Let me know when you heard enough. 2018 terroristic threats conviction.
Yeah, what year are you in now?
2018. It go real slow.
Yeah.
2018, another shoplifting. 2018 trespass conviction. 2018 probation violation. Another 2018 arrest, FTA for obstruction, public intoxication. Another 2018 wasn't his year. He got 2 more trespass arrests in 2018. 2017 theft by taking. 2017 shoplifting, 2 counts, 1 count of obstruction. What else? 2015 terroristic threats conviction, felony, and 2 counts of trespass convictions.
All right, that's good. I think I get the gist of it. That's a decent summary. Who's prosecuting?
That would be ASG Tortorello.
Okay. Go ahead, ASG Tortorello.
Yes, Your Honor. This is Defendant Posey, is that correct, Your Honor?
Yes.
So for this case, Your Honor, it occurred on November 3rd, 2022 at the Quick Trip, 855 Peachtree Street Northeast in Atlanta. Officer N. Shorter and Officer J. Mock of the Atlanta Police Department responded to a criminal trespass at the incident location. And upon arrival, the officers learned that the defendant, Michael Posey, came to the incident location and stole alcoholic beverages and attempted to flee. An officer working an extra job at the incident location was able to detain the defendant. And upon further investigation, officers learned that the defendant was issued a criminal trespass notice on October 25th of 2022. And the defendant was arrested for criminal trespass, and these events did occur in Fulton County, Georgia. Your Honor, for this, we're asking for a $1,000 surety bond for the defendant to stay away from the incident location, that Quick Trip, and no drugs, alcohol, no weapons, and no new violations of Georgia law. Of course, Your Honor, giving this defendant's 99 cycles, and I believe he had several recent arrests last year, December 21 of 2021 for simple assault, disorderly conduct at a Clayton County State Court. That was a conviction. June 4th, 2021, aggravated assault reduced to simple battery at a Fulton County Superior Court. He had an arrest back in March of this year for disorderly conduct, simple battery, and criminal trespass and terroristic threats. This was done by the APD. So for that reason, Your Honor, we believe $1,000 surety bond is more than reasonable for this matter and for this defendant. Nothing further.
All right. Ms. Gant?
Thank you, Your Honor. Mr. Michael Posey is 57 years old. He has been in the Atlanta, Georgia area his entire life. He has 3 children, ages 8, 7, and 18. He completed 2 years of college in the area of business administration, and he is currently employed at Dunkin' Donuts. He denies the allegations. I certainly acknowledge my client's history, but even with 2,000 arrests, he still enjoys the presumption of innocence. Your Honor, I am requesting a signature bond on Mr. Posey's behalf, and if Your Honor determines that he is ineligible, then I would we would certainly not be opposed to the $1,000 surety bond, and we are unopposed to the stay away. But I would just remind the court that, or inform the court that he doesn't have the means to pay anything toward bond. He's very concerned about keeping his job, Your Honor. Thank you.
And where's his job again?
Dunkin' Donuts.
How long has he been there?
He did not state, Your Honor.
And then what was the incident location? 855?
I'll get that for you, Your Honor. It's 855 Peachtree Street, Northeast in Atlanta. It's the Quick Trip.
Mm-hmm. I didn't get Ms. Tortorello from pretrial. Did we have any, do you have any recent FTAs in the last 5 years?
I got at 2019 FDA out of Fulton, April 11th, 2019 out of Fulton County, January 30th, 2019 out of Fulton County, November 1st, 2018, that was the arrest was done by APD, and a June 9th of 2018, a Brookhaven arrest for FTAs.
Or FTAs, okay. All right, I will go ahead. I'm sorry.
Oh, I'm sorry, I apologize for interrupting.
Go ahead. Ms. Gant.
I inadvertently interrupted.
Oh, okay. I'm gonna go ahead and give the $1,000 surety bond, just to make sure he understands the seriousness of the charge. $1,000 surety bond. Again, stay away from the Quick Trip at 855 Peachtree Street Northeast. No drugs, alcohol, or weapons while on bond. And then our last case, which is position 4, 22 CR 007569J. This is the case against Wanda McClure. We have 2 charges. One is SB and the second is public drunk. Their appearance has been waived. These both have the offense date of November 3rd. I want to caution everyone when you're speaking, don't want to hear any of the charges related to that, for the confidentiality and the safety of this defendant. And if you can't, then we may move into breakout for that purpose, but I believe we can all govern ourselves accordingly with any of those type charges. All right, go ahead, pretrial. Can you do that for me?
Yes.
Okay.
Third arrest. Last arrest was in 1993. It's for PI and obstruction.
Okay.
And before that was in the 80s.
Gotcha. All right. ASGLS Duncan.
Yes, Your Honor. This incident did occur at the Hamilton E. Holmes MARTA station located at 70 Hamilton E. Holmes Drive, Southwest in Atlanta. In this incident, the defendant told the victim, Isabella Johnson, that's ISABELLA, that she wanted to put her mouth on the victim's body parts. And then she launched forward towards the victim. Her mouth made contact with the victim's body parts between the victim's legs. Here we have a concern about the risk of reoffending in this case. As preacher has stated, this defendant does have a previous offense of this nature, and we do have a concern that this defendant may be a danger to the community, given this seems to be a random attack, that they in no way knew each other while at this location. As far as the public drunk goes, the defendant was making loud and boisterous and inappropriate comments and contact with people that they did not know at that location. Given this defendant's history, the nature of the offenses alleged, we're going to be requesting a $5,000 surety, which we believe is more than reasonable. That's $4,500 for the SB and $500 for the public drunk. We ask for no further contact with the victim in this case, name previously stated on the record. We're going to ask that this defendant stay away from the AG Homes MARTA station, have no alcohol, drugs, and weapons, and no further violations of Georgia law, given the concerns that, this person did actually make contact with the other. So we request that bond, and we believe it's more than reasonable. Nothing further from the state.
All right. Ms. Gant?
Thank you, Your Honor. Ms. Wanda McClure is 63 years old. She has been in the Atlanta, Georgia area her entire life. She does have family here, including a sister. She completed 10th grade, and at this point, Your Honor, she is retired. She is, of course, on a limited income. She does not have anyone to help with her bond. She expressed to me that she was very concerned about being able to pay her bills, Your Honor. She denies the allegations. She is presumed innocent. And regarding my client's history, of course, as we heard, it is quite remote, 1993. We are requesting a signature bond for Ms. McClure, as she, again, does not have the means to pay anything toward bond. We are unopposed to the no contact order. She does not know the complaining witness. And Your Honor, we would ask that any stayaways from MARTA be with regard to any active, if there are active restrictions. And that's my argument, Your Honor. Thank you. Signature bond.
Okay.
Recommended, if I neglected to say that.
And even though this defendant's previous similar offenses are remote, this is a bond here, so it is relevant to the risk of reoffense. And we just like to state that for the record, and nothing further from the state.
Okay. All right. I am going to order a surety bond in the amount of $4,000. I'm going to and I'm sorry, let me change this. I'm going to order $4,000 signature bond through the jail, which will be $3,500 on the SB and $500 on the public drunk, so total of $4,000 signature bond through the jail. I'm going to order a stay away from Hamilton E. Helms MARTA station, and no further contact with the victim, Isabella Johnson. All right.
Thank you, Your Honor.
All right, thank you. Anything else?
Nothing further from the state.
All right.
Or from the defense.
Thank you. Ms. Grace, when you're ready, we'll reconcile.
Okay, Judge, what are we going to do with add-on position 1?
Reset it till tomorrow.
I'm not sure how long the loan out is to Cobb County, so it may be one where we're just gonna have to reset it until he returns.
Yeah, we'll just keep resetting.
Can he log on from Cobb County?
Probably could, actually.
They do it in felony courts that we do. That's why I was asking.
Yeah.
Let me reach out to the jail and see if they can make that arrangement. Thank you so much,
All right.
Mr. Howard. I appreciate that.
Thank you.
Listen, you do.
But for now, we'll just reset it till tomorrow.
Yeah, reset it till tomorrow. If she gets the information, fine. If not, they may reset it to Monday, and by Monday, I'm assuming Deputy Falk will be able to maybe get a response from an email or something.
Yes, I definitely by Monday, I will be able to have something in place.
We'll make sure we're not in trouble and reset it for tomorrow just in case, and then by Monday, can probably do something.
Okay, Judge, we'll do. Position number 1, $4,000 pretrial bond per judge. Position number 2, $5,000 good bond. Position number 3, $4,000 pretrial bond per judge. Position number 4, $4,000 SOB through the jail. Position number 5 is a $1,000 good bond. Position number 6 is a $2,000 SOB through the jail. Position number 7 is a $2,000 pretrial bond. Position number 8 is a $2,000 pretrial bond. Position number 9, reset further notice. Position number 10 is a $4,000 good bond. Position number 11 is a $2,000 good bond. Position number 12 is a $3,000 good bond. Any questions or concerns?
Position 8, I thought it was a $4,500.
Say I was gonna wait till you got done to go back to 8.
In the pre-trial.
8 was
$4,500 bond?
yeah, 4,500. Signature bond through pretrial.
Okay, it's changed, Judge.
Thank you. And then what did you have again for 12?
$3,000 good bond.
Okay, gotcha. Anything else from anyone?
No.
No? All right, have a great weekend.
You too.
All right.
Thank you, Your Honor.
Thank you, Your Honor. You too.
Everybody, have a good one.